case separate from regular calendar. This is Han versus Chen. Since we're doing it before the regular call of the calendar, I'm just going to tell you how much time each party has. It's going to be 6-1 and 600 case. So let's hear first from the appellate. You're muted. We can't hear you.
Good morning, Your Honor. Can you hear me now?
Yes, we can.
Thank you, Your Honor. My name is Leon Behar. I represent the appellant. And most of what I want to say is really set forth in my brief and reply brief. But a couple of succinct points. Summary judgment is a drastic remedy, as everyone knows, which deprives a litigant of a trial. What the trial court erroneously did is deprive the appellant of a trial on several issues. In this
Let
case,
me ask you, let's get right to one of the main issues, which is whether or not you're required to have an expert opinion or expert testimony to establish whether or not something is or is not a fake antique. What was incorrect about the trial court's determination that in the absence of an expert being submitted in the exchange of discovery, you could not proceed with your claims that these were fake antiques?
Excellent question, Your Honor. Thank you. What was wrong with it is that the appellant purchased the antiques from the respondent, and then she gave them back. And he said, "I'll take them back because I found out they were fake." Okay, my client found out they were fake. He says, "I'll take it back." Now, last time I heard, selling antiques is a crime, but I wasn't the attorney involved in that issue. But once the respondent took it back and gave $25,000 as a refund to the appellant, we don't have to prove whether or not these antiques were fraudulent, were fake or not.
Yes, I'm not sure I'm following what you're saying, because one of your claims is that there was a fraud because the antiques were fake. How can you possibly establish? I know one of your claims is just for the refund of money, but some of it is for are based on a claim that they're fake antiques. So you're saying the court was correct in dismissing those claims?
No, because if you, in my brief, in my footnote 2, there's cases that say that there is no reason and there's no requirement to submit an affidavit during discovery in contravention of what the court ruled, and this is ultimately one of the issues the court has to determine is whether Rule 13C of the commercial rules actually supersedes 3212B of the CPLR. And there are lower court cases that say they do not, and you don't have to submit expert testimony in a motion for summary judgment. Okay, and that's one of the things that I submitted in my brief. It says in Freiman Mechanical versus Dormitory, which is on page 5 of my brief, the Supreme Court held that the court still cannot decline to consider expert reports on summary judgment solely on the basis of the third-party defendant's failure to timely identify its expert rule. The court rule 13C should be read in harmony with the statutory law CPLR 3212 as enacted by the state legislature. So if you're asking me the question, that's what's wrong. You don't have to show under Rule 13C an expert testimony, and that doesn't supersede the summary judgment motion on summary judgment.
But ultimately, sir, at bottom, do you acknowledge that there does need to be expert testimony on the subject of the authenticity of Chinese antiques, putting aside any procedural issues that may arise in this case?
No, because once there is a refund, it took it out of the issue. So, for example, Your Honor, if I buy a pocketbook on the street and I say it's a Gucci, and I go back and say, and I go back to the vendor and say it's not a Gucci, and he says I'll take it back and I'll refund you the money. So I don't have to show any longer that it's fraud or fraudulent because they took back the antiques. We don't have the antiques anymore. The respondent took them back and paid them back.
But wasn't the refund a relatively small amount in relation to the alleged value of the otherwise authentic Chinese antiques?
So far, because the appellants, the respondents said, I'll pay you back a little bit at a time. And the record is replete with $5,000 checks. I'll pay you back a little bit of time. And then when he refused to pay any longer, that's when this lawsuit ensued, because he was trying to drag her along. Remember, he's a so-called feng shui master. He's a manipulator of my client, and my client was undergoing a divorce, and she was troubled. And so she gave this money to him, thinking that it's an antique. It's not an antique. She says, I'll take it back. It was refunded.
Well, counsel, let me just ask this question. Other than the refund of the money, which could be some acknowledgement maybe that it was not an authentic antique, was there anything else in the record that would support your position besides the refund?
There are text messages, there's emails that's in the record, which we cite in our brief. And again, if you took them back, then I have to pay you back the money. I'm refunding the money. So that's why you don't have to show that they're genuine or not, because I took this. We don't have these antiques any longer. She took them back. He took them back. So that's the issue. The issue
Is that undisputed that all of the items were returned? Is that an undisputed fact, or is it disputed?
It's as far as I'm concerned, I can show you there's the records on page 60 to 62, 65 to 66, 166 to 167, 1568 to 1570. We gave them back, and he refunded 5 checks of $5,000 each. So
okay, you're going to have time for rebuttal, and your time is up. So let's hear from opposing counsel about what you're going to have a minute for rebuttal. You'll have rebuttal.
Thank you.
Okay.
Thank you, Your Honor. Meyer Swazi, English and Klein. I'm Randall T. Eng for the respondents. If I may, Your Honor, this matter is very simply about alleged fraud, and there has been no demonstration
Well,
that...
let me ask you a question just in response to what he just said. Is there a dispute about what has and has not been returned to your client?
There is a dispute. As a matter of fact, there's an acknowledgement by the appellant that she kept a Gualin statue, which she says she purchased for $18,000 that was not returned. She said that she wished to retain it. Now, we don't know if she wished to retain it because she acknowledges that that was not a fraud, or she is willing to pay for that particular object. Value of objects is based essentially on what someone is willing to pay for it. I'm thinking of the recent example of someone paying $1.5 million for a baseball that was hit by Aaron Judge. That baseball has a retail value of $25. However, someone found that it had a value of that and paid it. But getting back to fraud, Your Honors,
Counsel, can I just ask one question? The affidavit that was by Ling Lee, I believe the person's name was, how should we view that in the context of the plaintiff's position?
Most respectfully, Your Honor, it should be rejected because it does not comply with the rules of the commercial division. There was no notice given of it. There was no opportunity to depose the purported expert. And it's interesting that the appellant makes reference to having passed various pieces by high-end auction houses. And we have an affidavit from a Queens storefront auction house that purports to be expert. But of course,
but counsel, this is Judge Singh, that really goes to the weight of that affidavit, not whether it should be rejected. But I'm more interested in the questions or the points that was raised by your adversary. They say they've returned all the goods or all the antiques. How in the world are they now able to get an expert if the antiques are in your possession to address the issue of whether there was fraud, whether they're authentic or not?
Well, Your Honor, that is in dispute as to whether or not the items were...
Well, you've referenced one statute, sir. Sir, you've referenced one statute you say that wasn't returned. Is that the only one? I mean, no. Maybe there's a...
There are others. if you look at the deposition testimony, there is a clear issue of fact as to what was returned, how it was returned.
So with
there is
respect
no-
to the items that were returned, how would plaintiff be able to get an expert to opine on the provenance of those items?
Well, the appellant is arguing initially that the items were fraudulent when she took possession of them. So it's a question of whether or not the appellant is able to characterize those items at the time she took possession of it. I know Your Honor is referring to the fact that they may no longer be available for her to present to an expert, but it's too late in the day, too late in the game.
Oh, but why is that? Why is that, counsel? Isn't there a simple way of handling this? We go to trial because clearly there are a lot of disputed issues of facts in terms of what occurred here. And then experts on both sides can opine as to the authenticity of those items.
Well, Your Honor, I don't know if an expert would be able to opine that the item that they have an opportunity to inspect would be the same items that were initially turned over when these transactions began. And if I may, Your Honor, I believe that the court below properly put this matter in perspective in saving a portion of the first cause of action and granting summary judgment in the others. There is clearly a dispute between these parties that can only be solved by a trial of the facts, evaluating all of the evidence. By preserving that part of the first cause of action, the court is giving the parties an opportunity to, as Your Honor has pointed to, present what evidence it can muster in order to sustain their individual positions.
Counsel, just to let you know, you have 1 minute left, okay?
Thank you. The court below made a difficult situation more focused and subject to resolution. The dispute between the parties can be solved by a trial on the merits regarding what survives. And furthermore, I wish to add that the text messages that have been referred to, the court is aware, of course, that the text messages do not have the same status as emails, although it may be evolving in that direction, and that the text messages that are spoken of do not contain the signature, electronic or otherwise, of the person to be charged. Thank you.
Thank you very much. You have 1 minute for rebuttal.
And I'll be very succinct, Your Honor. The baseball analogy, the baseball is authentic. The antiques are not authentic. We send them back. We don't have them any longer. And to Justice Singh's question, how were we supposed to do to authenticate anything if they took them back and there was a refund of the money? Albeit she only paid $25,000, but he did pay something towards the $965,000 that we paid, and therefore it takes it out. But what the lower court did.
Don't you still have your claim though for the refund of the money paid? Is it you just didn't get summary judgment, but you didn't get dismissed either? You still have a claim for trial for refund of what was paid, right?
He bifurcated cause of action number 1 and he dismissed cause of action 2, 3, 4, 5, 6, and 7.
But don't you still have a claim for a refund of what you actually paid? I mean, your big argument is you can't prove what it's worth because you returned it, but you returned it to get a refund and you still have a viable claim for a refund.
Right, but there's a cause of action for the cemetery lots. That's cause of action number 3, which he dismissed outright. Where we can't get the $120,000 back. It's not just about the antiques, which we paid $965,000 for. It's all $120,000.
Counsel, how do you get around the statute of frauds with respect to the cemetery plots?
It's very simple, Judge. If I gave you $120,000, you're supposed to perform. And if it's not for cemetery lots, give me back the money. That's why enrichment.
Thank you. Thank you very much.
Thank you, Your Honor.
Okay, thank you.
Yes.
No, there's no rebuttal since you didn't cross appeal.
Thank you.
So we're done. So thank you very much. Have
I
a good day.
appreciate it so much, Your Honor.
Okay.
Bye-bye.
Thank you.